if they occur to me and they seem to be critical to this issue. All right, motion for new trial tonight. Now, from there, let's go to sentencing. State.
Your Honor, I have several witnesses that would like to address the court.
Sure. And I'd invite you to consider, if they're going to be brief, you can put them either in the witness stand or at the podium, whichever you prefer. If they're brief and you want to have them at the podium, great. If they're brief and you want them in the witness stand, great. You can use either place you want to go.
Let me call Alan Seaman.
Mr. Seaman, come on up, please. Good afternoon, Mr. Seaman. If you'll raise your right hand. Do you promise the testimony I'm about to give me the truth, the whole truth, and nothing but the truth?
I do.
All right, please tell us your name.
My name is Alan Seaman.
And Alan, A-L-L-E-N?
A-L-L-E-N-S-E-A-M-A-N.
Thank you very much. Ms. Roberts.
And what is your connection, sir, to Scott Wilson?
I'm an attorney, but I'm not here in an attorney's capacity. William and Cindy Wilson are dear and treasured friends of mine and have been for some time.
Okay, and did Mr. Wilson, the father of the deceased, ask you to speak on his behalf?
Actually, Cindy Wilson and William Wilson both.
Okay, both did.
And Cindy asked me to make a statement on her behalf.
Okay, please go ahead and do.
Thank you. Speaking for Cindy, Your Honor, I would like to tell you the events of February 12, 2010, and how this horrible night has affected our family. At 1:50 in the morning of February 12, 2010, the police called William at his home. They were searching for the driver and passengers of a Hyundai they'd found and were asking if he was the owner of the car. William told them it was his son's car and gave them Scott's cell phone number. William then called his daughter Christy, who was also living in Orlando and attending the University of Central Florida. When Christy answered the phone, William realized that she was safe, but was told that Scott wasn't with her and she hadn't spoken with him for quite some time. Relieved that Christy was safe, we now turned our attention to finding Scott and finding out what had happened to him. We drove out to Wellington to look for the car and decided the best idea was to trace the path that we thought Scott would have taken to his mother's home. When we got to South Shore Boulevard and Lake Worth Road, we came to the roadblock. The officer told us that no one could pass. William identified himself and told her the police had called him earlier. The officer made a call, came back, and said we still could not go in. We asked if an ambulance was there, and we were told it had been, but it had left already. With that, William frantically began making telephone calls. He called Wellington Regional Hospital. He called JFK Hospital, hoping to be told that Scott had been taken to either facility. Unfortunately, both hospitals told him that no accident victim had been recently admitted to either facility. They told us to check Del Rey Hospital and Palms West, which we did. But again, Scott wasn't found at either of those locations either. We drove around to see if we could get into the accident scene by a different route. While driving, William received a call from a sheriff's deputy saying that they were coming to our home. William told them that he was already in Wellington. It was 2:40 in the morning. We waited for a very long time, hours. There were patrol cars all over, most with their lights flashing. Again, we asked if an ambulance had come to the scene, and again we were told that one had been there, but had already left. Again, we repeated our calls to the area hospitals, frantically trying to find out if Scott had been admitted anywhere. Again, the answer was no. We asked if any unidentified victims had been admitted that evening. Again, no. At 4 o'clock in the morning, an officer informed us that they had found evidence of alcohol and drugs at the scene. Well, Scott was a non-drinker. Scott never took drugs. So we knew at that point that another car had been involved, and whoever the driver of that car was under the influence of either drugs or alcohol. But again, we waited. At 6 o'clock in the morning, someone finally approached, a new officer. He parked his car and he approached us. He came over to William, the father, handed him Scott's driver's license, and asked him, "Is this your son's driver's license?" Which William said it was. That he said, "I'm terribly sorry, Mr. Wilson, that your son is gone." Well, William had been fearing the worst. Hearing the actual words, being told his son was dead, was a terrible shock to both of us. It's a moment I will never forget. William had no choice at that point but to call his daughter Christy and break the terrible news to her. We then drove to where William's former wife, Lily, lived, out in Wellington. William called her from the driveway and told her that he was there. He had something to explain, that he had to talk to her. She came to the door and let William in. With that, he repeated the terrible news again, that Scott was gone, that he died in a terrible and senseless accident that night while coming home to celebrate his sister's birthday. When Scott died, a big part of William died with him. William is a dedicated father. He was extremely close and had an extremely good relationship with his son. Scott and William were best of friends. They shared their love of football by going to games together or by watching the games on television. Even when Scott went off to college, they would call and text each other as the games progressed. When Scott was home, they played tennis, ping pong, basketball, board games, you name it. Every summer, they would spend countless hours together in the pool. Scott's home was the home that all of the friends knew. William was the father that all of Scott's friends and all of Christy's friends knew and loved. Scott was a chip off the old block. William loves the Florida Gators. Scott loves the Florida Gators. William loved to bowl. Scott loved to bowl. William's favorite restaurant was Scott's favorite restaurant. William has this crooked smile, the same smile Scott had. Both of them had the same quick wit, the same competitive streak, and the same love and lust for life. When William and Scott were together, there was always laughter in the house. Their constant competitive banter would make everyone laugh. They would even challenge each other to who was the taller, an ongoing debate that neither of them would ever concede. When Scott died, a part of my husband died with him. He still has his memories, and the memories often make him laugh. But then the laughter turns to tears as William realizes that memories are all he has left. Simple things can cause him the most terrible pain. Questions from strangers like, "How many kids do you have?" bring tears to his eyes. The day before Father's Day, William received the coroner's report. And out of a dedication and duty to his son, he knew he had to read it. He had to read how Scott died in the bottom of that canal, a canal that John Goodman left him in to die. John Goodman and his supporters bragged that he was the CEO of his father's business by the age of 30. Well, Scott will never see his 30th birthday. Goodman's supporters talk about his charity, but where was his sense of charity when he ran away and left Scott to drown? All he had to do was stand there, just say, "Help me, there's a car in the canal." But instead he ran, leaving the police to solve this terrible puzzle, leaving everyone to wonder, leaving the father and Cindy there for 4 hours to wonder, what's happened to Scott? Where is Scott? John Goodman didn't just break the law. He broke rules of common decency and simple humanity when he ran away to save his own skin and left Scott to die. John Goodman asked for leniency, but what has he shown this family except for lies, lies, and more lies? John Goodman took this young man's life and then tried to run away. He and his lawyers have come into this courtroom and attacked everyone and everything, the judge, the jury, the lawyers, the bailiffs, even the Wilson family. Everyone else is to blame except poor, misunderstood John Goodman. But if it weren't for John Goodman's decision to party all night, take drugs, drink like there's no tomorrow, and then get behind the wheel of a car, Scott Wilson would be here today, and we wouldn't be in this courtroom. John Goodman has displayed no sympathy, no real sympathy for Scott or his family, no remorse for his actions, no sign that he acknowledges that what he did was terrible and what he did was wrong. But the evidence is in. The jury has spoken. The evidence is overwhelming. It's now time for John Goodman to pay for his crime. In the Wilson family view, and the view of Cindy, he's no better than a common criminal. And it's about time that he finally pays for his crime by serving a sentence that puts him in prison for a very long time. How long? We leave to your discretion. Thank you very much, Your Honor.
I have questions of him. Chris?
Good afternoon.
Good afternoon, Your Honor.
Raise your right hand. You promise to tell the truth?
Yes.
Please tell us your name.
Chris Jones.
Chris Jones.
Chris Jones, yes.
Thank you so much.
What is your relationship to the Wilson family?
I'm a childhood friend of William's. I've known him all his life. This is a statement from him that he was going to read, but felt too emotional to carry that out. And so, with the pleasure of the court, I'd like to read it for him as if I was him. Thank you. My name is William Wilson, and I'm the father of Scott Patrick Wilson, a young man who died on February 12, 2010, as a result of the reckless and criminal conduct of John Goodman. I am writing this letter so as to provide the court with my views as to Mr. Goodman's conduct on the night he caused my son's death, in order to allow you to have some insight into the emotional devastation which John Goodman's actions have caused my family and me to suffer. My former wife and I have 2 children together. Our son Scott, had he survived, would be 25 years old. Our daughter Christy is 21. On the day he was killed, Scott was driving to our home in Palm Beach County, where a celebration had been planned for his sister's birthday. Christy had turned 19 on the 8th of February, just 4 days before the wreck, and her family and friends were coming together to celebrate her last birthday as a teenager. Scott had already graduated from college with a degree in mechanical engineering and was living and working in the Orlando area. Christy was a freshman attending the University of Central Florida, Scott's alma mater. I last saw Scott on February 8th, 2010, when I had driven to Orlando to join in a birthday dinner for both he and Christy. Little did I know that this would be the last time I would ever see my beloved son. For exactly 4 days later, Scott's car would lie crumpled and sinking into a canal just a few short miles from his childhood home. His life would slowly be ebbing from his oxygen-starved body. Meanwhile, his killer, John Goodman, instead of attempting to flag down a passing vehicle or trying to help Scott escape his rapidly sinking car, would simply run away, interested more in saving his own skin than doing anything that might save my son's life. It is important that this court understand the events of February 12, 2010 from my perspective, and I would hope that John Goodman, who has never offered a single word of sincere remorse, know what he put our family through by his choice to flee and hide, rather than report the incident to the police as the law and common decency requires. Early in the morning hours of February 12th, I was awoken from a deep sleep by a call to my home. A voice at the other end of the line was frantically asking if I owned a 2006 Hyundai Sonata. Still groggy at having been awoken in the middle of the night, I didn't immediately realize that I was being asked about my son's car. As my mind cleared, I suddenly became aware of the gravity of the situation. Scott's Hyundai had been involved in a terrible accident, but the police didn't know who was driving his car or if there were any passengers. Confused and quickly turned to concern as I explained that my son was due to drive into town that evening and my daughter Christy was expected to ride along with him. At that point, I had to assume that both of my children had been in the car, and whatever tragedy had befallen Scott also involved Christy. Immediately after that call ended, I dialed Scott's cell phone, but no answer. With mounting concern, I called Christy. I was thankful and relieved when Christy answered, thinking that both my children were safe. Relief quickly turned back to fear as my daughter explained that she and Scott had decided to drive separate cars. While Scott had left Orlando shortly after work that evening, Christy had not heard from him and had no idea if he had been in a wreck and was okay. With my concern and fear increasing by the minute, my then-fiancée Cindy and I both raced to the car in order to drive out to Wellington in the hope of locating my son. The western entrance of Lake Worth was blocked by a sheriff's patrol car. The deputy driving the vehicle could provide us with no information. He had no idea of my son's whereabouts and could give us no assurances that Scott was all right. With my fear turning to panic, Cindy and I drove through the back streets of Wellington in an attempt to gain access to the scene from the east end of Lake Worth Road. There again we were stopped by a patrol car blocking the road. Again the deputy could tell us nothing. We asked if Scott had been located. Was he injured? Had paramedics been called? Was Scott taken to a hospital? None of our questions could be answered because, as we found out later, the only person who survived the wreck had already left the scene. By this time, it was clear that whatever had happened involved more than a mere car accident. Despite Cindy's attempt to reassure me, I began to fear the worst for my son. By this point, more than an hour had passed since the initial call to my home. 2 a.m. had come and gone, and we'd still heard nothing of my son's condition. Our way to the accident scene being blocked, my fiancée and I had no choice but to park on the side of the road and sit for 4 long hours, waiting to hear if Scott was dead or alive. Seconds seemed like minutes, minutes like hours, and hours like days. 4 long hours we waited for news, hoping for the best but fearing the worst. As more and more time passed, we eventually turned to despair. Hope eventually turned to despair. These hours of waiting and not knowing if Scott was healthy or injured, dead or alive, were nothing short of a living hell. For 4 long hours, I sat at the side of the road, waiting for word, suspended between hope and despair, and all because John Goodman was so drugged and drunk that he couldn't or simply wouldn't accurately report the accident to the police. All because John Goodman chose to flee instead of attempting to flag down a passing car. All because when he later gained access to a phone, John Goodman chose to call his girlfriend rather than immediately dialing 911. All because Goodman knew he was in trouble and therefore tried to run away. The one person who could and should have let everyone know that my son was trapped in a car, upside down in a canal, thought only of himself and nothing for his victim. At around 6 o'clock in the morning, almost 5 hours since I first received that harrowing middle-of-the-night phone call, a Palm Beach County homicide detective came and gave us the news every parent dreads. My son, Scott Wilson, was gone. At just 23 years, Scott's hopes, his aspirations, his dreams for a life journey he had just begun were crushed, stolen from him by a man who simply walked away while Scott lay bruised and dying in the suffocating darkness of a filthy canal. A parent's greatest fear is receiving a telephone call in the middle of the night informing them of a son or daughter's injury or death. Everyone thinks they can imagine the terror of such a call, of their anguish in learning of a child's death. I now know I did. I now realize, however, that no one really knows what it feels like to lose a child until it actually happens. The experience is simply too horrifying for words to adequately express. The grief is too horrible for the imagination to grasp. Having faced the horrible pain of losing my only son, I wouldn't wish that anyone be forced to endure such a tragedy, not even on John Goodman, my son's killer. For over 2 years, my family has endured the pain and loss of a son, and for Christy, the death of her brother. For 2 years, we have watched as his accused killer has walked free among us, living a life that my son will never again have a chance to enjoy. I have made few public comments, and I've sat silently at the back of the courtroom as Goodman and his attorneys have spun their fantastic tales. I've listened quietly as Goodman and his lawyers have tried so desperately to portray him as a victim rather than admitting to his terrible crime. Despite his protests, neither I nor any member of Scott's family have ever asked that John Goodman be put on trial because of his wealth. We've asked only that he be brought to justice for his criminal actions on the night of February 12th, 2010, when he drove drunk and drugged and at over 60 miles per hour crashed his Bentley into my son's car. For watching Scott's Hyundai slip over the embankment and into the canal. For knowing that my son was trapped and dying, but instead of lifting a finger to help, trying to run away and hide. Evidence of John Goodman's guilt is overwhelming and clear. Any reasonable jury would have no trouble assessing his guilt, and Goodman's jury did just that. Justice and my son's memory demand that John Goodman now be held accountable for his actions. I ask that John Goodman be sentenced by this court to a prison term to commensurate with the horrible crime he has committed. I hope that once committed, Goodman at long last reflects on his terrible decisions and his extreme misconduct on the night he took Scott away from his family and friends, the night he stole the life of an innocent young man, a night whose memory will haunt me and my daughter Christy for the rest of our natural lives. Thank you, Your Honor.
Mrs. Wilson.
Good afternoon, Ms. Wilson. Thank you for coming down here today. If you'll raise your right hand, please. Do you promise to tell the truth?
Yes.
Please tell us your name.
Lily Wilson.
Thank you very much. What would you like me to know?
I want to start off by saying Sunday's going to be Mother's Day. And Scott will not be coming home. I'm going to read a letter, very brief. Dear Judge Colbath, my son's death has a tremendous negative impact on our entire family and friends. He had his whole life ahead of him. Those who knew him can confirm that he was a wonderful son, brother, grandson, godson, nephew, cousin, and friend. He had an amazing disposition with a gentle, loving, kind spirit that was always thoughtful of others. By dying at such a young age, he will never have the opportunity to work as a professional after graduating from engineering school. He will never have the opportunity to marry and raise a family of his own. He will never have the opportunity to pass on his intellectual gifts and accomplishments to future generations. He didn't even have the opportunity to donate his organs to save others' lives, as he had once told me he had elected to do. For 2 years, I have been asking myself, how could this have happened? What steps could have been taken during that valuable time frame when Scott could have still been saved? I'm asking for justice for the death of my son, a wonderful, irreplaceable life that ended far too soon. I have discussed with Ms. Roberts that I consider her experiences and judgment essential for presenting a suitable recommendation to the court. I trust your decision in determining what constitutes an appropriate sentence. Thank you.
Thank you, Mr. Searcy.
No, the state has no more witnesses.
Okay. All right, I'll go over and I'll allow the defense to present some witnesses, and then after you present your witnesses, I'll take argument from both sides before I impose a sentence. Mr. Black.
Our first witness is Greg Goodman.
His first name is?
Greg.
Greg.
G-R-E-G. It's the defendant's older brother.
Thank you. Good afternoon. Please raise your right hand. Do you promise to tell the truth?
Yes, sir.
All right, please tell us your name.
I'm Judge Colette. I'm Greg Goodman. John is my younger brother. Obviously, I've known John. I'm going to read a statement if that's
fine. Just more comfortable. That's fine.
Yes, sir. Obviously, I've known John all his life. John has always been a loving, caring brother, and has always been there for me and my family in good times and bad. I know John as well as anyone knows him, and I've also spent a lot of time with him since this tragic accident in February of 2010. John is devastated and remorseful over the accident, and he has wanted to reach out to the Wilsons from day one, but his attorneys had advised him against that. The newspaper and the media do not describe or talk about the John Goodman that his friends and family know. They talk about a fictitious character that they have made up to try and create more drama around an already tragic and horrible situation. John, as well as the rest of our family, have been thinking about and praying for Scott Wilson and the Wilson family. This young man's death and his family's struggle with what has happened plays a huge part in my wife's, my 4 children, and my life. All of us think and talk about this tragedy every day. I do not know how we could handle losing one of our children, and I do not pretend to know how the Wilson family and their friends feel, and I hope that I never do have to go through that. My youngest child was walking with John one day and was photographed. The photograph was in the Palm Beach Post. Someone wrote in that newspaper that they should kill my son because he must be related to John Goodman, and that obviously devastated me. John, as well as our whole family, live with this tragic accident every day. Again, I know John as well as anyone knows him, and I know contrary to what the jury believed and what the newspapers wrote, he would not have left Scott Wilson to die. Had he known he was in life sentence for this accident in John's life. I know this has destroyed a lot of people's lives, and there are consequences for his actions. John has 2 young children and many other people that rely and depend on him. I hope that you would take into consideration all of the others that were not responsible for this accident that will have irreparable harm from a long prison sentence for John. I ask that your sentencing is reasonable and that John is remorseful and is paying for this accident every day of his life. To put him in prison for a long period of time helps no one. If he is out and has a lifetime of community service and can continue to raise his family and continue to contribute to the community, that I feel like that helps many people. Thank you, sir. I appreciate your time.
Thank you, Mr. Goodman.
Your Honor, our next witness is Hutton, spelled Hutton, Goodman, his nephew.
Thank you. Good afternoon.
How are you,
So
sir?
raise your right hand, please.
Yes, sir.
Do you promise to tell the truth?
Yes, sir.
Please tell us your name.
Hutton Goodman.
All right. What would you like me to know?
First, I'm John Goodman's nephew. He's also my godfather and one of my closest friends. I also did a statement of sorts. I've known my uncle all of my life, and in every interaction with him, he's proven himself to be a kind and compassionate and selfless individual. An example is one time, when I was 6 or 7 years old, I grew up in Houston, Texas, and for a 6 or 7 year old in Texas, during the rodeo they have Go Texas Day, where everyone dresses up as cowboys and stuff. And my dad fell down the stairs and tore his tibial tendon and then the ligament in his other foot. And wasn't going to be able to go, which was pretty devastating for a 6 or 7-year-old. And my Uncle John showed up at my house the 6 a.m. that next morning without telling anybody anything, and spent all day with me. Took me to the rodeo, took me dressed up in the most ridiculous cowboy costume you've ever seen, and spent his whole day with me. And the image that has been portrayed by the media over the last 2 years could not be further from the truth. My Uncle John is not the unremorseful monster that people seem to want to believe that he is. I have both stayed and lived with my Uncle John several times, both before and after the accident, and I have seen firsthand how this tragedy has changed him. I have heard several statements claiming that my uncle has shown no remorse and taken no responsibility for his actions. From what I have witnessed firsthand, nothing could be further from the truth. From the day of the accident, my Uncle John has thought of little else but Scott Wilson and the pain of his family and friends. There is nothing my Uncle John or any of us would not do to take that pain away. The death of Scott Wilson has destroyed my uncle. The initial disbelief that a young man lost his life has now become a daily reckoning for him. He was, is, and will continue to be a broken man. Scott Wilson was my age. In the days that followed the accident, I remember my Uncle John looking at me and saying, "Hutton, he was your age. It could have been you." I can say with unwavering confidence that my Uncle John would have done absolutely anything in his power to save Scott Wilson had he known he was in the canal. I ask that you give my Uncle John a short sentence because he poses absolutely no threat to the community, and to give him a lengthy sentence is essentially to impose a life sentence on someone who's nearing 50. I would also ask that you consider in your sentencing the many people that depend on my Uncle John, whether it be my grandmother, John's mother, who my uncle takes care of and who lives at John's home, to the many people who count on him for employment, to the hundreds in the Wellington community who rely on the draw from the Polo Club to keep their small businesses afloat. My uncle is a vital part of the lives of many individuals and families. My Uncle John is one of the best people I know. To impose a lengthy sentence upon my uncle would benefit no one and hurt so many. A great man once said, "An eye for an eye leaves the whole world blind." To give a lengthy sentence to a man with no prior history of bad behavior and who has done so much good, to me seems like vengeance, not justice. If given the opportunity, my Uncle John could do so much good. Please consider imposing a punishment that could stand to benefit many and prevent future tragedies instead of retaliation in determining the fate of my Uncle John. Thank you.
Thank you very much.
Your Honor, our next witness is Betsy, B-E-T-S-Y, Abel, A-B-E-L.
Good afternoon, Miss Abel. If you'll raise your right hand.
Judge Connor.
Do you promise to tell the truth?
Yes, sir.
Please tell us your name.
It's Betsy Abel.
Abel.
There's 2 L's.
Okay. Thank you. And Ms. Abel, what would you like me to know?
First, let me say that I cannot fathom the depth of grief and sorrow that the Wilsons are having to endure because of the loss of their son. Nothing compares. It is heartbreaking beyond words and never far from my mind. And I am so sorry. With regard to my brother John, I love him dearly. We have been close throughout our lives. And I'd now like to talk about the qualities of my brother that I've seen and that I think are important to know before he's sentenced. My brother is generous and has been that way his whole life. John helps support our mother, and he's always been very attentive, loving, and dedicated to her welfare. He so often included her in his plans, whatever they were, when she might otherwise have been alone and lonely. Since she's become quite immobile, he has her live with him much of the year where he can spend time with her. He took the initiative to find her a physical therapist, then encouraged her to stick with him when it was hard. And this has made a huge difference for her physically, mentally, and for her overall quality of life. This was something the rest of us were never able to do for her. And he calls her every single day that he can to check on her. John has also been a loving, caring, kind, and supportive brother to me, always exhibiting great interest in me, my family, and my educational, philanthropic, and professional endeavors. He likes talking to me about counseling because I worked as a counselor, because he's always interested in better understanding himself and others so he can become a better person. Another thing I want to share about John is that he shows great care and interest for how other people are doing. He wants to make sure everyone's comfortable, has what they need, okay, and happy. John has often helped out friends and employees, putting their interests ahead of his own. For instance, several years ago, a woman in Wellington came up to tell me how John had taken care of medical costs for one of her family members, and she said the family could not have afforded this care. She noted that this was something that John would never tell anyone about, but she wanted me to know. And then she said there were many like her whom John had helped. Later, when John was having financial problems, I had to talk him out of giving a large sum of money to a childhood friend who was used to having John help him. And John often continued to pay employees whose service he no longer was using until he could be sure they had other employment because he was concerned about their welfare. John has also been a kind uncle to our daughter, who spent a lot of time around John and loves him. She worked at a horse barn in Wellington at times when she wasn't at school, and John always offered her a place to stay if she needed and looked after her well-being while she was away from home. He's also made significant contributions to the Wellington community through his business and charitable activities. Many families have jobs and a better future, directly and indirectly because of John's work. John is a loving son, brother, uncle, and friend. There's one thing all of us close to John know, and that is that he would never leave a young man drowning in a ditch if he knew he was there. That is just not who John is. This was a horrific and tragic accident, and life will never be the same for any of us again, and it shouldn't be. John is never going to really be okay. When making your decision, Your Honor, I hope you will recognize the many contributions John has made and see what kind of person that he is, and please grant the most lenient sentence that you possibly can. And thank you for considering my comments.
Thank you very much.
Your Honor, I wanted to advise the court that John's mother, Harriet Goodman, is here. She is 84 years old and is under a lot of stress and anxiety, and she was going to make a statement, but I think the proceedings are a little too tough, but I wanted the court to know that she was here and wanted to say something. Would you want to give me 1 minute?
Sure.
Your Honor, Mr. Goodman is going to take his right of allocution.
Good afternoon, Mr. Goodman. And just please tell us your name for the record.
John Goodman.
Raise your right hand. You promise to tell the truth?
I do.
Oh.
I just wanted to say that from the second, the day after the accident, all I've wanted to do is reach out to the Wilsons and be with them and to cry with them and to, I can't imagine or even pretend to imagine what it would be like to lose a son. And every day I feel like I carry, Scott Patrick Wilson with me every day, and that's all I think about going forward. Is I know that I have to do good and be a better person and carry on whatever I can, and do good for him. And it's his short life. I just can't imagine what they must go through and what his sister Christy and his mom William. And it's just I mean, just to be a part of this is just so tragic and horrible. I don't know what else to say. I'm just really, my heart goes out to the family, and I'm so remorseful and sad.
Thank you very much. Anything else? All right. Let me take argument then from the First Estate and then defense.
Your Honor, it certainly hasn't gotten any easier over the last 26 years. These are always tragic and sad, and 9 times out of 10, it's because the defendant is not a bad person. Occasionally we have one that's bad, and it's a pleasure to lock them up. But for most purposes, it's an ordinary person who does an incredibly stupid thing. I disagree that this was an accident. An accident is when lightning strikes a tree and falls in front of your car and you hit it. That's an accident. This wasn't an accident. He intended to drive. He intended to drink. He did not intend to kill Scott Wilson. But nonetheless, his intent to do the other things caused Scott Wilson's death. I just never would consider it an accident, and the legislature decided that to take the word accident out of the statute, and it's now considered a crash. And I think most importantly, parents are not supposed to bury their kids, period. All he had to do was stay there, flag down a car. And unfortunately, and why this happened, I don't know, but Mr. Goodman thought more about himself. He knew he was in trouble. He knew he was involved in a crash. He knew it was a car. He knew the canal was there. He lived out there. He knew all of that. He knew exactly what happened. But the problem was, I don't think he was used to taking care of himself. And when he realized he was in a heap of trouble, he reached out, not to the police, not to 911, which normal people would have, when they found a phone, screamed to the top of their lungs, I was just in an earth-ending crash. Please, God, please send somebody. But he didn't. The first call he made was to Carlos, his handyman or his employee, whatever he was, whatever the relationship was. When he was unable to reach him, he called his girlfriend. And only after Lisa Pembleton urged him numerous times to call 911 did he call 911. And I submit to this court, he has shown absolutely no responsibility in this crash whatsoever. He came into this courtroom, he blamed it on the car, he blamed it on his pain, is why he drank afterwards, and he blamed it on a non-existent concussion. And I submit to this court, he absolutely has, he's remorseful because he says he's sorry, okay? And if you look at the case law that I supplied the court, that's insufficient. It's simply lacking. You have to accept responsibility for what you did. And I do not think that Mr. Goodman has, or quite frankly, I don't think he ever will. The people that talked to you up here talked about how people in the community depend upon him, what he's done for Polo Club and all of that. A life is gone. A young man who had his entire life in front of him was taken by a drunk. Plain and simple. And the purpose of the punishment codes in the state of Florida are to punish, not to rehabilitate. As the primary purpose is to punish. He may be a generous man to the people that work for him or the people that he cares about, but he wasn't generous that night. He was a coward. And he did to me the most horrible thing on earth you could ever do, and that is leave that child in that canal to drown. I don't think there's, I think it probably is the most horrible death on earth, and I pray to God that Scott Wilson was unconscious. when that car went in the canal. There is no excuse for what he did, Your Honor, and I submit he must be punished. And the state is asking that you sentence him to 20 years in the Department of Corrections. Obviously, by law, his license is permanently revoked. He will never drive again. And respectfully, Your Honor, we ask that he be sentenced to the 20 years.
Thank you very much, Ms. Roberts. Mr. Black.
Thank you. Thank you, Your Honor. Sitting here today, I think, is the most human part of this whole process. Many times we lawyers, we use rules and procedures and objections, cases and all of that. And that's fine up until today, up until this moment. But now we've got a probably one of the most human processes there are, without too many rules. And it's really, Your Honor has to listen to human beings, evaluate the tragedy here, and fashion some type of a sentence that meets justice. And of course, philosophers for centuries have been trying to define justice, and it's a difficult thing to do, and Your Honor has a very difficult job here. And I want to make some arguments about why John Goodman's sentence should not be 20 years. And let me make this clear at the outset. I'm not here asking for leniency. I'm not asking for mitigation. I'm not asking for any downward departures from the guidelines. The guidelines start at 11.5 years, 11 and a half years. That takes into account the DUI manslaughter and the failure to render aid. And what the statute says and what the rule says is that is the reasonable sentence unless there are some aggravating factors or some mitigating factors. And I am going to talk about things which mitigate sentence, but I'm not asking you to go below the 11.5, and I'm not asking for leniency. Now, John Goodman is a human being. And we human beings are fraught with errors and mistakes, and we do stupid things. And John Goodman, up until the night of this crash, lived an exemplary life. But he's going to be punished for what happened that night. The court has, the jury has found him guilty. Despite all the arguments we have raised, the court has adjudicated him guilty, and he's here for sentencing, and he's going to be punished today. But the question is, what should that punishment be? And we're not asking for rehabilitation. We're not asking for any reason other than what is the modicum of punishment that this man deserves. What does his act that night, taking into consideration who he is and what he has done, what punishment is there? And when I think about punishment, I think all of us know that in our lives we have done some good things and we have done some things we're not proud of. And I think when we all are judged, we're hoping that some of those good things that we have done can in some way mitigate the bad that we have done. I wanted to give you a quote from a sort of an unusual source that really struck me when I was thinking about this today. People, even more than things, have to be restored, renewed, revived, reclaimed, and redeemed. Never throw anyone out. That was by Audrey Hepburn. It's a woman who was an actress who became an activist in her life and was involved with many different kinds of people. And I think there's a lot to that. You know, you have here for sentencing today a man who's all too human. And I want to show you some reasons why the minimum reasonable sentence is adequate under these circumstances. Your Honor has received a pre-sentence investigation, and that investigation says that retribution is what should generate the sentence. It says that retribution within the justice system is defined as a proper return for the defendant's negligent actions to the family of the victim, and the punishment must be driven by that. The fact that an innocent life has been lost, and recommends 20 years in the state penitentiary. The state also says in their memorandum that he deserves 20 years because an innocent life was taken. And there's no question that an innocent life was taken. But this idea that people are actually sentenced based on retribution, I think, is a false one. If the punishment is actually determined by the death of an innocent person and nothing else, then everybody would receive the same sentence. We have, and I will tell you, for example, just the same time as our trial. A man received a 9-year sentence for hitting and killing a grandmother and for leaving the scene, and was charged with DUI manslaughter. And it was a horrible crime where the woman's body was dismembered. And if retribution drove the sentences, why would this man receive 9 years? And then there's a case, which I believe was Your Honor's case, of a woman from Wellington, got 10 years probation on April 9th for a DUI manslaughter, and she was impaired on prescription drugs and alcohol. Now, granted, she had medical problems, needed a liver transplant within 2 years, but if we're really just talking about retribution, then there should not be sentences like that because an innocent person died, a 38-year-old young man who was on a bicycle. And another case came up of Sabrina Fiorento, in which she received a 15 years of probation, and she has to serve a weekend on the anniversary of the crash each year. And her license is suspended for 3 years. Now, I don't pretend to tell you that you should give John Goodman the same sentence as them, but I point that out to say that this idea that we run things by retribution is not what happens. Now, several people today have mentioned that John has not shown remorse, or not before today shown remorse, and the state in their sentencing memorandum says that he has not taken responsibility for his actions because he has gone to trial. And he has put this before a jury, and therefore he did not accept responsibility. We tried many times prior to trial to engage in plea bargaining in this case, and the state would never give us one. The closest they ever came is if you offered us 15 years, we might consider it. That's what happened with the plea bargaining in this case. And now, because John Goodman did not enter into a plea bargain like all these other people, they now want to punish him because of that. And I think that presents a dilemma of constitutional proportions. On the one hand, they failed to engage in any good faith attempt to resolve this case with a plea bargain. Yet on the other, they say, well, he went to trial, so we ought to severely punish him up to 20 years because of that. Another 8.5 years more than the minimum sentence. So what do you have here? It's like a Hobson's choice, which is the antithesis of our constitutional criminal justice system. A defendant does not have a constitutional right to get a plea bargain. And I'm not saying there's anything wrong with the state not offering one. And I'm not suggesting that they have to, that they don't have to offer him probation or weekends in jail or a 9-year sentence. They don't have to do any of that. They can go to trial if they want to. But they can't. But a defendant only has two options, either to plead guilty or to go to trial. And if you withdraw one of those options, and the only thing he can do is go to a trial, how could you punish him for going through that trial? Our system only offers those two alternatives. There's nothing else. And when the state's responsible for taking away one of those two alternatives, I don't believe that they can ask that this man be punished because of that. There's also 3 cases I wanted to bring to the court's attention regarding this, that the fact that a person goes to a trial and does not show remorse during a trial cannot be used as a ground to aggravate his sentence. The Florida Supreme Court held this in 1990 in the case of Holton v. State at 573 South 2nd, 284, in which the court said that exercising your right to go to trial, which is a constitutional right, and to maintain your innocence, cannot be used to preclude either mitigation or to enhance the person's sentence. In Gilchrist v. State, again, the Florida Supreme Court in 2006 at 938 South 2nd, 654. Excuse me, it's the 4th DCA, not the Florida Supreme Court. That you cannot take into account when entering sentence that a person exercised his right to a trial. The same thing just was decided by the 3rd District Court of Appeal. Remorse is a matter that he was going to use in fashioning the sentence, and the Florida Supreme Court, the 3rd District Court of Appeal reversed because of that. Now, we are not asking for a downward departure for acceptance of responsibility, because I'm asking for a guideline sentence. But I want to address it to show you that John Goodman has in fact accepted responsibility. Acceptance of responsibility. Show you that John Goodman has in fact accepted responsibility. Long before this accident, he purchased an insurance policy for $50 million. This insurance policy was not free. He paid every year premiums for this policy. He was a responsible person for having insurance. When you look at these cases where people have horrible accidents like this, it's very tough, if at all, for them to be compensated. In this case, not only did John show responsibility by having this insurance, he hired his own lawyer to put pressure on his insurance company to settle with the Wilson family. And he pushed for them to settle right up to the policy limits. And they settled this case for $40 million. Even though he was told most verdicts would be somewhere between 5 and 8 million. Now, I'm not here suggesting that getting paid money can in any way substitute for a loss. And we cannot ever say that. But our legal system our legal civil system says that the best that we can do is to see that there is monetary compensation. And because of his responsibility in doing this, at least there was compensation. It is, I know, wholly inadequate. But nevertheless, I think John Goodman has to be understood as a person who took responsibility and prepared for the fact there could be some necessity for this. By the way, the PSI says the defendant is very remorseful in that the victim's family was suffered a tragic loss of a member of their family. So they made a finding that he was remorseful. There's one other thing that I wanted to address on the issue of remorse, and it's come up today, and other people have mentioned it, that how can John Goodman, through his lawyers, make objections and motions and go through a trial and what have you? Well, that's my responsibility as his lawyer. And I make no apology for being aggressive, trying to argue everything that I can, to take advantage of every rule, of every case law, and what have you. And I'm proud to be a lawyer. And I do that because I believe that's my responsibility. However, that should not in any way affect the sentencing or punishment of John Goodman. This is the way the system works. This system works by having aggressive advocates, and you cannot punish a man because his lawyer tries to defend him in the best way possible. Your Honor, under Florida Statute 921.00265, the Florida legislature has said that the lowest permissible sentence provided by the calculations from the total sentencing points is assumed to be the lowest appropriate sentence for the offender being sentenced. These guidelines were created in some way to try to take out the variability in sentencing, although I don't think that's possible because this is not really something that can be guided by statutes and graphs and outlines and what have you. But what the Florida legislature says is that the severity of the sentence should increase with the length and nature of the offender's prior record. And that policy statement is repeated in the rules. So what is there about John Goodman that should increase his sentence over the 11 and a half years? Your Honor, we have submitted to the court letters. We have not called all these people as witnesses because that would take quite a period of time. But in determining whether or not John Goodman is somebody whose sentence ought to be increased, the severity of his sentence increased, I think the court should take into account who this man has been in his life. Condra Seeley wrote a letter to you talking about charities and the charity that John, and the many charities that John has involved himself in. And I point this one out because she says he could have delegated the running of different fundraiser meetings to others, but no, he was 100% involved. He's not a person who just sends in a check. There's a letter from a Cynthia Catchis, who's the executive director of a program. She lived in Wellington and moved to the Pine Ridge Indian Reservation in South Dakota to help people with Indian tribes. And she says that even though she doesn't know Mr. Goodman, she knows so many people who know him, and some of her best friends work for him. And she said, I can't help sharing what a good man this man is. Bill Ray, who's worked with John for 7 years in fundraising. Most people who are set in life financially usually give donations to different charities, but John goes way beyond that. He doesn't just give a monetary donation. He gives his time and energy and goes to every length to make sure the money goes to the cause it was raised for. I've seen him in many cases hear about a charity event that didn't raise what they needed and hoped. John, without anyone knowing, helps them with his money. I'm sure every letter you read will help you understand more and more what a good person John is, but 1,000 letters couldn't express what a kind and thoughtful and creative person John Goodman is. They say the best way to tell what a person is made of and who he truly is by talking to the people that work with him or for him on a daily basis. You can ask anyone that's around John Goodman, from the gardener to the CEO. They will all tell you he's the nicest, most considerate, good-hearted person they have ever met. Brandon Phillips. Within my profession, there are many individuals that have huge amounts of wealth and power, but I can honestly say that out of the many wealthy people that are in our industry, John Goodman is by far the most generous and thoughtful person there is. He uses a large majority of his wealth to help and benefit and improve the quality of life for the people around him. The town of Wellington would not even be close to where it is today without the support of John Goodman. Kathy Scott. His gestures of philanthropy are seen in many areas, no matter how big or small the cause. He genuinely gives to so many organizations, and every gift comes from his heart. He listens patiently to every story told and is eager to help those in need. I know I can always count on his support when needed, whether it is for a local hospital, a homeless shelter, or a school for children with special needs. A number of people, there are several letters, one from Arlene Page and others, who talk about the Venceriamos Therapeutic Writing Center that John has helped create and supports, that brings autistic children to be with the horses. There's a letter from David Putlock, who is the director of the Texas Children's Cancer Center, in which he talks about John being one of the leaders in the curing children's cancer at the hospital. There's a letter from Lucas Van Allen talking also about the Curing Children's Cancer Fund, the Bunakani Fund to cure paralysis and spinal cord injuries. Georgette Escobar talks about his work helping with breast cancer research. Richard Pryor worked with him in the Red Cross. There's a letter from Susan Barry, whose husband worked for John for 5 years, who passed away, and John paid for the funeral and all the details because he was his employee. There are others talking about various other charities, the Catholic School Fund. Orrin Ingram worked with John at the Miami Project to Cure Paralysis, the Texas Curing Children's Cancer Fund, the Vincent Ramos Fund, Diabetes Research, the Equus Foundation, Boys and Girls of Palm Beach, and many others. Tim Gannon. He's been involved in countless charities, the Miami Project to Cure Spinal Cord Injury, of which I co-chaired with Tommy Lee Jones, and he helped raise over $500,000 for research. He sponsored the 40-goal Outback Challenge, which raises over $300,000 every year for the charity. And when you talk about employees, there are numerous letters from people who worked for John at the Polo Club. And here's one from Gerardo Arroyo. I ask on behalf of myself and fellow co-workers that have looked up to Mr. Goodman and appreciate everything he has done for us, if you could show him leniency. So that's the kind of person that John Goodman is. And under the guidelines, is there evidence that we ought to increase his sentence by 8.5 years as the state requests? Is there anything there in his background of charities, of employing people, of creating the Polo Club? And I'm not saying the fact that he created this club ought to be a mitigating circumstance. But when you're talking about a person's background, when the legislature says you increase the severity because of the length of the bad conduct of the person, here's someone who has only done good in his life. He helped people. He worked in these charities. He created an organization that brings, I think I saw $20 or $30 million to Wellington every year. Everything he has done in his life has been positive. Is this the man that we ought to almost double his sentence? And I know that people have, and rightly so, said he should be punished for leaving Scott Wilson. But I don't think he was really convicted of that. He was given an aggravating sentence, or is giving aggravation under the guidelines for it. That brings it up to the 11.5 years. But we objected to the court's instructions on this aggravating because what happened with the state deliberately did not charge him with leaving the scene of an accident as a substantive crime, because that requires the two elements of knowledge and willfulness. They would have to prove that he knew that Scott Wilson needed help and that he willfully declined to give it. Instead, the standard instruction refers to Florida Statute 316.062, which is a non-criminal traffic violation. And that the standard instruction crafted the aggravator in such a way that if you leave, it's strict liability, that there's no requirement of intent, no requirement of willfulness, no evil intent. If you leave, you get this aggravator. And we had asked for an instruction adding willfulness and knowledge to the instruction, and the court denied it. We also asked that the court give a theory of defense instruction saying that a head injury could be used as a defense to the issue of willfulness regarding leaving the accident scene, but the court also did not give that. So the jury did not pass on these things. What the jury said is that there was this DUI manslaughter, and he left. The United States Supreme Court said in Morissetti versus United States that crimes have to have some type of mens rea. They have to have some type of intent element. You can have strict liability crimes, but they're like that traffic infraction. They have to be lower level crimes. They can't be serious crimes. And you're being asked to sentence him as if he was convicted of knowingly and willfully leaving the scene of the accident. And quite frankly, what he was convicted of is not that offense. And I don't believe that the court can use that in aggravating his sentence. And that part of the conviction has been accounted for in the sentencing guideline of 11.5. The state admits in their sentencing memorandum the following: that the defendant has no prior criminal history, He has no prior bad acts. This was an isolated incident in his life. It is undeniable that Goodman is sorry for what he did, and that he did not intend to harm anyone. So, Your Honor, if in fact this statutory scheme means anything, the lowest reasonable sentence, according to the legislature, is 11.5 years. We have not asked Your Honor to go beneath that. But is there anything in his background, is there something that causes a reason to increase the severity of that sentence? And I submit to you, not only is there no such thing, but John Goodman, up until the night of this crash, not only lived an unblemished life, he led a life of helping other people. And I don't know how, under any kind of a fair system, a man who has only done good in his life, but because of this horrible accident, one that the state says, the state legislature said deserves an 11.5-year sentence, I don't know why the severity of that should be increased based on this man's record, on what he has done with his life. And as I said at the beginning, I think we all hope that when our day of judgment comes, that not only will we be taken into account for the bad that we've done, but we hope that the good we have done will mitigate that. Thank you.
Thank you very much, Mr. Black.
Yes?
May I respond briefly?
Let's brief.
Real brief.
Real brief.
Okay. As always happens in these cases, I always get these other cases that we've resolved. They brought them up. Just to clarify the record in this case, two of the youngsters that he suggested got probation, both of those young people, they were teenagers. They accepted responsibility for what they did. There were no depots. Nothing was done in the case. They came to my office and said they were guilty and that they wanted to be punished. Certainly not what Mr. Goodman did. Ms. Sigmeister is dying of liver failure. I decided that rather than have the taxpayers pay for her liver transplant, that we would put her on probation, and she gave $100,000 to the victim's family, which was about to lose their home because of the fact that their bread earner had been killed. So let me clarify those sentences. And neither one of these three people that he suggested received probation left the scene of a crash. None of them did. And in expectation that they were going to argue for a downward departure, in light of the case law as it's read, you don't need to consider the lack of remorse because they did not raise that issue. So it truly cannot be considered in light of the fact that they didn't ask for a downward departure. And that's all. That's it, Judge. Thank you.
Thank you, Ms. Roberts.
No, I'd just like to correct one thing. In the case of the gentleman with the 9-year sentence, he was charged with DUI and failure to render aid. And I'm surprised that Ms. Roberts has forgotten that.
There was a plea to the court, and he drove to his mother's house a block away and called the police.
Thank you for those presentations. And let me start my part of these proceedings by extending my condolences to the Wilson family and also to the Goodman family. These are horrible, horrible cases from a criminal justice standpoint. Scott Wilson's loss was senseless. His death was senseless. He was on the eve of the fullness of life, and having that taken away from him by this criminal act is just that no money can compensate someone for that loss. Nothing can. But on the civil side, all they got is money to deal with. And on the Goodman side of the family, I know that Mr. Goodman and his family members, his loved ones, his supporters, they're tortured too by this. Nothing good's going to happen from this. My sentence isn't going to fix anything. And so it's a difficult thing. Ms. Roberts hit the nail on the head. Most of these cases, we're not dealing with criminals that society cheers to see, get what's coming to them. Most of the time, it's law-abiding citizens that, do horrible things. And that brings up some of the variables that we judges are encouraged to consider when imposing a sentence. And so I'll share those with you so that you see how it is we think, or society, the viewers of this proceeding will have a little bit of an appreciation for kind of the factors that are considered and weighed, and it's the stuff that I think someone who sat and thought about it would kind of get to the same kind of things that were important and perhaps were not important. Generally speaking, a sentence in these type of cases is to accomplish a couple things. First of all, punishment. This sentence is to punish criminal behavior, punish intentional decisions to drive, intentional decisions to drink when Mr. Goodman still had the mental wherewithal to make the decision not to drive, and he chose to drive when he was drinking. And I agree with the jury's verdict. The jury rejected, beyond a reasonable doubt, the notion that Mr. Goodman became intoxicated after the crash and not before. And so I accept their finding, and I agree with it, that he was drunk way beyond the amount of drinks that his theory of the defense suggested, that they only had 2 or 3 drinks or a .04 or lower at the time of driving. So punishment is a large component of this sentence. Another thing is deterrence. And deterrence comes in 2 forms. Deterrence, general deterrence. And general deterrence is so that people who see guilty people get punished hopefully say to themselves, whoa, I wouldn't ever do that crime because I don't want to be punished like that. And that's what general deterrence is. And hopefully the people watching these proceedings will appreciate that when you drink, don't drive. Find a cab. Find a friend. Find an alternate means to get around it. I'm not saying don't drink. I'm just saying don't drink and drive. And this was a senseless accident because Mr. Goodman decided to drive when he was too drunk. The other type of deterrence is specific deterrence. And specific deterrence is pointed at the person who's committed that crime. And that is, we want to deter criminals from repeating their criminal conduct by having been punished. Rehabilitation is a component of sentencing, but that's not, in this case, a key factor. The state has acquiesced, the defense has acquiesced that rehabilitation is not the type of, typically those are the more traditional type of crimes that we talk about rehabilitating somebody. Restitution is a component of crime, and that those are typically in theft cases. Restitution, as I've indicated previously, and everybody agrees, cannot be made in this case. Mr. Goodman, through his insurance company, has the Wilson family has entered into a settlement, but that's not restitution. That's just that's all the system can offer up. And retribution, and Mr. Black touched on that. And retribution is a legitimate consideration in imposing a sentence. And when I think of restitution, I think of the right society has to say, aha, he got his. He got what was coming to him. And it's a pressure valve for society to have that sense of guilty people get punished. And it's okay to feel good when that happens. I do agree with Mr. Black, however, that retribution in these settings does not warrant increasing a punishment beyond that which I feel is appropriate, but rather it's a component that comes intrinsically with the sentence to a greater or lesser extent. Let me share with you some factors I did not consider and would be inappropriate, and I gave no weight to. Mr. Goodman's wealth. This is not a case about Mr. Goodman's wealth. Mr. Goodman has had the good fortune in his life to be born into a family of means, and good for him and good for them. And it is not to be, it's inappropriate for society or for a judge to say, you know what, let's take that rich guy down a peg. And if I caught a whiff of that's what this jury was doing, I would have granted him a new trial. And I don't think that's what happened. It's an inappropriate consideration, and I give that no weight whatsoever. Exercising his right to go to trial. That's a slippery slope. It is laudable for the criminal justice system, prosecutors, judges, to look favorably upon people wanting to own up to their criminal act and say, I'm sorry, I did it. And the first step to rehabilitation is contrition, is acceptance of the criminal act, to own it. The flip side of that, however, would seem to be, someone might think the corollary would be, well, then let's punish somebody for denying their criminal act. Mr. Goodman entered a plea of not guilty. That required the state to have this trial and prove what they've alleged. But it is inappropriate to punish someone for exercising their right to go to trial. And it is a slippery slope for the defense to allow their client to say, please go apologize, because those apologies may be used in trial. So it is a strategic move in some instances. But I will share this with you. I am a firm believer in the jury system. I am a firm believer that it is appropriate for a completely guilty person to require the state to prove it. And I hold no grudge in my own heart or animosity by someone going to trial. And even if I did, I wouldn't let it filter into my sentence. So there is absolutely no factor given to my sentence as a result of Mr. Goodman choosing to plead not guilty and requiring the state to prove it. That is healthy for our society. All of us are the beneficiaries of people, guilty people, going to trial and requiring the system to prove with lawfully obtained evidence the guilt of those people who are accused. And so there is no negative impact on my sentence because Mr. Goodman exercised that constitutional right that we all have. Here are some factors that I did consider in imposing my sentence. The defendant's lack of prior record. Mr. Goodman, up until February 12, 2010, was a model citizen, was an asset to his community, was a person who gave back, by all accounts, in many ways. And this sentence won't preclude him from continuing to do that. He will certainly be going to prison for a time. But that won't preclude him from continuing to be philanthropic. He can do that if he chooses to. I hope that continues to remain in his heart. Another consideration that I gave a lot of value to was the level of intoxication, over double the legal limit. This wasn't a case where Mr. Goodman went out for a night and said, I'll have 1, 2, and gosh, I don't know how much. I know I had 2 or 3 drinks, but I don't know what my blood alcohol level is. Or, I feel the effects of alcohol, kinda, but I don't think I'm impaired, or I don't think I'm over the 0.08 blood alcohol level, and so I, got a guess, and I guessed wrong, but it was a real close call. This wasn't even close. There was nothing close about this. Mr. Goodman was extremely intoxicated. His blood alcohol level verified that, and so I gave that a lot of weight. His driving at the time, his speed at the crash, his running through the stop sign, his driving recklessly without any regard to other traffic that may have been out there, and that is more evidence of his level of intoxication. And also I gave a lot of weight to that which everybody's offended by, and I am too, by the defendant's actions after the crash. His conduct from the moment the crash happened to the time he finally came to be in the custody of law enforcement was to save himself, to do whatever he could to avoid the liability, the criminal responsibility that he knew was going to visit him from the moment of the crash. And I accept the jury's verdict that he acted willfully and deliberately. He knowingly left the scene of the crash, and it wasn't to go get help. It wasn't because he was disoriented. It was because he wanted to try to figure out a way to save himself. He had an opportunity, although it might have been brief. He had an opportunity to try to save Mr. Wilson. He could have gotten in that canal. Maybe it would have been to no avail. But I believe what the jury believed, and that was he knew he pushed that car in the canal. He knew there was someone in that canal, and he left to try to. When given another thing I considered was the defendant's age. And Mr. Black rightfully reminds the court that, how do some of these other people get these other sentences that seem incongruous with what's going on here? Is it just fate? Is it just a criminal justice system that's fickle? And I don't think so. Mr. Goodman is fully mature and knows right from wrong. And some of these other cases, when you get teenagers, young adults that make bad decisions, their brain's not quite right. I mean, the science is in on this, and human brains aren't settled in and fully rational thinking and mature until somewhere between, depending on if you're a man or woman, somewhere between 18 and 25. And so the law makes an accommodation for youthful offenders in other statutory sentencing schemes. But a man Mr. Goodman's age knew right from wrong, had world life experience, knew how to drink, knew how to make responsible decisions when he did drink, and chose not to. So lack of youth and immaturity is a factor I consider. Another thing during this trial is when the defendant testified on the stand. I believe his testimony was a complete contrivance. I think it was pure sophistry. I think it was a vain attempt to create a story and weave it in and out of the seams of the state's case to try to make it look like he might have been not guilty. I think that's what happened. Actually, I don't put much weight on that in my sentence. I'm not increasing his sentence by that, but I think that the jury rejected that story beyond a reasonable doubt, and I do too. So based upon those factors, Mr. Goodman, I'll accept the jury's finding you guilty. I'll adjudicate you guilty of DUI, manslaughter, and failure to render aid, as was charged in the information. And I'll sentence you to a term of incarceration in the Department of Corrections, 16 years. I'm going to fine you $10,000. I'm going to impose the mandatory court costs. And I hope that the time goes easily for you. I don't wish you a bad time. I hope that you have an opportunity to do some good with the next years of your life. You're still going to be young enough when you get out of prison to enjoy some life ahead of you. But Scott Wilson won't. And so with that, these proceedings, the sentencing aspect is adjourned.
There is a 4-year mandatory minimum.
4 years of that sentence is a mandatory minimum. Do you want me to consider your bond argument now, or do you want to save that for some other time?
No, we'd like to hear it now, but I do have an objection, Your Honor.
Sir.
I object to Your Honor's sentence because you have taken into account at least one factor which is not accurate, and a sentence cannot be determined upon inaccurate facts. The court said that one of the influences of your sentence was because the jury found that Mr. Goodman knowingly and willfully left the scene of the crash. They did not find that, and in fact the court declined to give our instruction which required them to find that. So the court, using as a factor that the jury found that he knowingly and willfully left the crash, I believe is an unconstitutional one.
Thank you for pointing it out. It was, if I said that, I misspoke. I intended to parrot the language in the information, and that the jury found, and I accept, that the defendant did willfully fail to remain at the scene of the accident and give information and rendered aid. And
There's
so,
no willful.
Right.
We asked that willful be given, and the court declined it.
I'm not trying to convince you I'm right.
Okay, yes, I know. I'm sorry. You're right.
Well, I don't know if I'm right. The appellate court will let me know. All right. Credit for time. That sentence will be reduced by credit for time that Mr. Goodman has already served. I'm also going to revoke his driver's license as required by Florida statute, and that's going to be a permanent revocation of his driving privileges. And how much does anybody know what the credit for time served is? I took him into custody at the day of the
March 23rd.
March 23rd. Someone do a quick calculation for me so I can announce that on the record.
Mr. Goodman says 50 days.
50 days? I'll go with 50 days unless somebody corrects me. Minus 50 days for credit for time already served.
I'm sorry, the date was April March 29th?
I'll tell you, the verdict was rendered on March 23rd.
Originally one day when he was originally booked.
Yes, plus another day. Was he in and out? Did he spend the night on his booking when he got booked in, or did he just go in and out?
Judge, as I recall, Mr. Goodman was taken into custody early in the morning. I think it was May 19th was the date of
He
arrest.
got out later that day?
Much later. I think it was, might have been 10 or 12 hours later.
Okay,
So
but
we'd
just
ask
one
for
day.
credit for that one day.
Okay, so 50 plus 1.
And the state raises 50 days.
Okay, 51 days credit for time served. Do I have a judgment? So you put together a judgment?
I will, yes.
Thank you
I
so
thought
much.
we had already done one.
No, Judge.
We didn't? Okay.
All right, Mr. Black, your motion for an appellate bond?
Yes, sir. Would it be inappropriate to ask for 5 minutes?
Let's take a break.
We have two witnesses.
Let's take a 10-minute break, and we'll come back and we'll hammer out the issue of the appellate bond.